Now our case was transferred already. Okay, transferred to a new branch of the same regional trial court. So we expect that it will be before a new judge. This was the result of the motion for inhibition of the previous judge, okay, filed against the previous judge. So the regional trial court made the following resolutions, now with the new judge, okay, before the new branch. According to the regional trial court, that Mary expressly admitted that Joey is an heir of the decedent. So this will make things a lot easier, okay? It is already admitted that Joey was an heir of the decedent. It was also admitted that Joey was clearly omitted from the last will and testament. So this will help the trial court resolve the issues before it, because it is clear that Joey was omitted. I think a mere perusal of the last will and testament will easily help you resolve this issue, whether or not Joey was omitted from the last will and testament or not. Okay? And finally, that based on the evidentiary hearings, Joey was preterited. So basically, the trial court said there was preterition. Okay? The Joey was not able to receive any inheritance from his father based on the evidentiary hearings. Why based on the evidentiary hearings? We ask ourselves, what is the reason for stating that based on the evidentiary hearings, Joey was preterited? No? Because a common position for this type of issue would be, say, a common position or a common opinion would be a mere checking of the last will and testament would tell you that Joey was preterited. Okay? That is not an uncommon position. That is not an uncommon opinion, but that is wrong. Okay, but that is not uncommon. Okay, as we will learn later on, why the phrase based on the evidentiary hearings, Joey was found to be preterited. Why not just based on the last will and testament? We can see it when you read the last will and testament. He was not included as one of the heirs. Why is it based on the evidentiary hearings? Okay. So we ask those questions in order to appreciate the lessons the Supreme Court is teaching us as they write their decisions. Thus, the regional trial court reinstated John Jr., okay, the son of the John, the decedent, John Sr., as administrator of the estate and ordered the case to proceed in intestacy. So the court allowed the proceedings to proceed, but in intestacy. Remember, before the previous judge, before the same regional trial court, but in a different branch, the trial court judge allowed the suspension of the intestate proceedings and ordered that the case proceed with the probate of the last will and testament. This is the opposite when it comes to this resolution by the new judge. The new judge allowed, okay, not only allowed, but reinstated John Jr. as the administrator of the estate, not executor, but administrator, because this tells you a lot. Administrator means the estate, he is an administrator of an intestate estate. And further, the trial court judge ordered the case to proceed in intestacy. It is the exact opposite of the order of the previous trial court judge. Okay? So you can review the previous videos to understand this further. Of course, Mary moved for reconsideration with the regional trial court, which the regional trial court denied for lack of merit. I think this is obvious. If you will look at this case, there is no good grounds, no, factual or legal, for Mary to sway the regional trial court to reconsider its decision. Okay? True, Mary's motion for reconsideration lacks merit. Okay? As we will discuss later on with more details in the part where the Supreme Court already resolved the issues in this case. Okay? So, at this point, we kind of know already where the case is going and how it will end. But of course, no, we can never be sure. Let us read further the Supreme Court decision, and we will do that together in the next video. So I'll see you in the next video.